Hi, everyone, and welcome Julie Raneda to the podcast of the Swiss Chamber of Commerce in Singapore. Let me start by congratulating you for your recent promotion to Managing Director at Schellenberg Wittmer, which is the only Swiss law firm in Singapore. Is that correct?
Thank you, Loretta, and welcome to our offices here at 6 Battery Road. And you are correct. Schellenberg Wittmer is the only Swiss leading law firm with an office in Singapore, and we are the only law firm providing Swiss law advice out of Singapore.
What does a Swiss law firm do in Singapore?
Swiss law firms traditionally are only based in Switzerland. They don't have overseas offices, so we are quite unique in that respect. And why are we here? We are here for our clients. First, our many Swiss clients who have operation in Singapore and in Asia, who have set up their regional headquarters in Singapore. So that's what we call our inbound work. But we have also now many Asian clients who need Swiss law advice for cross-border transactions or because they want to invest in Switzerland. And that's what I call our outbound work. Finally, we also practice international arbitration out of Singapore. As you may know, Singapore has become a dispute resolution hub, and it's one of the top 3 seats for international arbitration worldwide.
So we will go through all of these. But first, your firm is celebrating 10 years here in Singapore. So why 10 years ago did you decide to open an office in Singapore?
We realized quite early the importance of East Asia, Southeast Asia, and we wanted to not only be able to do business trip, but really have a physical presence on site for clients to be in the same time zone. Switzerland is the 9th largest investor in Singapore. And Singapore is Switzerland's main trading partner in Southeast Asia, the 3rd trading partner in Asia, behind Japan and China. So Singapore is a very important place for business.
What a Swiss law firm can actually do in Singapore and in the region where there are different law systems.
Schellenberg Wittmer is registered as a foreign law practice in Singapore. I myself and my colleagues are registered as foreign lawyers at the Singapore bar. And so in essence, that means that we can not advise on Singapore law with one exception, international arbitration proceedings seated in Singapore. But for all other cross-border matters, we assist our client with civil law and when Swiss law, and civil law more generally, and when we work hand in hand with local counsel in Singapore or in the countries where our clients operate.
Most of the countries use actually English law. So why someone would come to have advice from a Swiss law firm in Singapore or from the region?
Singapore is a common law jurisdiction, so are India and Malaysia. But there are very important countries around the region who are civil law jurisdictions. If I may say a few, and the main ones that are Indonesia, Thailand, Vietnam, and if you look a bit more northeast, Japan, South Korea, and not forgetting a major player, which is China.
What are the main differences between the Swiss law and the common law?
So without going into legal intricacies, I think the main difference is that Swiss law is based on statutes. It's codified, whereas common law, like English law, is based on case law, which are precedents by the courts or the judicial authorities.
But it's correct to say that the Swiss law is very popular, for example, in commercial trade. Is that correct?
Swiss law is the 3rd preferred law in international contracts behind English law and New York law. And in other words, it means that Swiss law is the preferred civil law for international contract. And there are many reasons for that. I think first reason is that Swiss law is codified, so it's in a statute, and it's available in several languages, including English, which makes it easy for international commercial relations. It's a very accessible law. unlike German law or French law, it's very easy to understand. It's quite predictable, it's business friendly, and it leaves lots of contractual freedom to the parties. So in other words, parties can really tailor their rights and obligations the way they want in their contract, subject to a few mandatory provisions of the law, of course, but these are very limited.
Does Swiss neutrality play a role in the client's choice?
Absolutely. I think Switzerland neutrality is very important also from a commercial perspective. When companies coming from different countries enter into a contract, they want to choose a neutral law to govern their relationship. And so Swiss law is a perfect choice for this.
As Swiss, we know that the Swiss neutrality has been a topic of discussion in the last couple of months and years for several reasons. Is this a topic among your clients?
I think people have been questioning Swiss neutrality in this case for, I think, two main reasons. First is that in the context of the war in Ukraine, Switzerland has officially aligned its trade sanctions regime with the EU sanction regimes. And no later than last week, Switzerland implemented the EU 11th package of sanctions against Russia. And so this is not something that Switzerland always do, align with the EU when you think about sanctions against Iran, Ivory Coast, and others. Switzerland is not always aligned with the EU. In this case, it had decided to follow the EU, I think, to reinforce the impact of trade sanction and make sure that Switzerland would not be a place to circumvent EU sanction. And the second reason for questioning Swiss neutrality, I think, is the nature, scope of the sanctions. In this case, which places a heavy burden on companies to be compliant and to do their due diligence. But I think Switzerland still follow its neutrality principle, which leaves room for, broad action for the Swiss government when it's necessary.
So international arbitration is one of your expertise. Could you give us an example of what kind of situation would need your intervention?
To give you an example, imagine a contract for the construction of a power plant between a German and a Chinese companies. Of course, the German company, in case of disputes, does not want to have to file a claim before Chinese courts in Chinese, under Chinese law. So the parties will usually provide in their contract for international arbitration in case a dispute arises. This means that they will be able to choose the rules applying to the arbitration, the seat of the arbitration. Do they want to have their seat in Singapore or in Switzerland as a neutral place again? They can choose their arbitrator. They can appoint arbitrators who have the right expertise, the right knowledge, the right cultural background. So there are many advantages for commercial party to decide to submit their dispute to international arbitration. And so we represent clients in this type of proceedings. At times, we also act as arbitrators in proceedings. So that's for the commercial aspect of our work. But we do also what we call investment arbitration, where we represent client investors against states, or we represent states who face claim from investors. And so this type of arbitration is not based on contract. It's based on international treaty, for example, bilateral investment treaties or international convention like the ICSID Convention.
Here in Singapore, some investors were actually suing the Swiss government because of the Credit Suisse bond, after the merger between UBS and Credit Suisse. Is this something, for example, that would require international arbitration?
Yes, so the Credit Suisse AT1 bondholders are currently looking at possible actions, including against Switzerland. And so one of the options they are considering, this is in the media, it's a claim under the Singapore EFTA agreement. And so that would typically be a case of arbitration.
You also specialize in trade sanction, economic sanction, another sensitive topic. We see sanction against Russia, but also against several countries in the region, Cambodia, Myanmar, North Korea. What is the impact on Swiss companies or on your clients more in general?
Yes, trade sanctions are a complex topic. It's, an instrument of international politics, so it evolves with the international events. So it has impact on the business, it has an impact on existing contracts, on future contracts to conclude. There is also, risk of fines, of criminal penalties in case of violation of the trade sanction. And importantly for a client, it's also a reputational risk.
How do you help and advise your clients to navigate through this sensitive issue and risks?
In a given situation, you may have different sanction regimes that come into play. If I may give an example. You have a company that is based in Switzerland. So that company is subject to the Swiss sanction regime because the Swiss sanctions have a territorial scope of application. So they apply in Switzerland. But then you have in that company a French trader that is working on a deal. So because of the nationality of that trader, the EU sanction regime will also apply to this transaction. And because the deal is denominated in US dollar, possibly the US sanction may also apply in this case. Because US sanction may have extraterritorial application and you have also secondary sanctions. So it may become very complicated, to understand how the sanctions play a role into the legality of a possible transaction, a possible contract.
Is this discouraging some clients, some companies to actually make business in the region because so many countries are affected or not?
I think trade sanctions are maybe not the most problematic issue in the region itself. Of course, you mentioned Myanmar, Cambodia, but I think the main trading partners, Indonesia, Vietnam, do not have sanctions in place. So I think there are other types of challenges, of course, for a client when they enter those very promising markets. At the same time, and I think what's important in these cases is, to have the right local partner, but also a trusted advisor to help you navigate all these challenges.
Around us, there are a lot of developing countries. Who is doing better from also a legal point of view in terms of developing and, getting their act together and then become a viable partner?
It's very important for those countries to offer a stable legal environment to attract investors. But, this is a slow process and there are progress that have been made. If I can talk about my own practice, international arbitration, you see that legal practitioners in the regions and governments are getting really interested in it. They are, developing international arbitration framework in the country that is attractive to investor also, so that the investor, have some reinsurance that when they invest, they have some safeguards, if you want.
International arbitration, sanction, class action. Do you sleep at night?
Now, I would lie if I say that I always keep my sleep, but no, I'm lucky. I have a good sleep overall.
Helping Swiss companies to establish themselves in Singapore is also very much aligned with another role that you just taken up, President of the Swiss Chamber of Commerce in Singapore, the first female, by the way. I think is worth celebrating. So let's talk about the female representation or women's representation in leadership in Asia. How are we doing?
No, so I think there are many successful women in leadership position in the region, and I can see that within our clients, women having leader position as CEO, managing directors, or general counsel, and to see that trend, that very positive trend, is very empowering. Now we still have a long way to go.
And how is the legal industry doing in terms of inclusion and female representation?
There have been many studies out there, including with regard to law firm, and we know that diverse legal teams are more successful than non-diverse ones. Diverse law firms are more profitable than others. The image of the company, both internally and externally, is better. So all this benefits everybody, the companies, the law firms, their client, their employees. And I think there are many initiatives out there by law firms to promote diversity and have a more inclusive environment. And this really has an impact. And we see the results of these initiatives. And maybe if I can share that Schellenberg Wittmer has been recognized as Switzerland Law Firm of the Year at the Women in Business Law Award 2023. And I'm quite proud of that.
Well, let me end on this very positive note then. It's about, breaking the glass ceiling in Asia, in the law industry, in your law firm for sure. Thank you very much for this fascinating conversation. Thank you, everybody, for listening and for watching, and stay tuned for more conversation about Swiss companies in Singapore.